You decide to bring a lawsuit against your doctor for being careless, causing you significant harm and injury. And now your attorney gets your case evaluated, has a medical expert review all your records, and determines that yes, you are correct, that you do have a valid basis for a case. Why do you also have to sue the medical group where the doctor works or the hospital where the doctor is employed? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so here's the scenario. You believe that your doctor was careless and caused you significant harm and injury. And now, your doctor denies all of your allegations. But why is it that when you know that your doctor was careless, why is it that your attorney who is drafting the legal papers necessary to start the lawsuit tells you, listen, we also have to sue the medical group that the doctor was employed by? Or if the doctor was employed by the hospital, listen, we also have to sue the hospital where this doctor worked. Why is that? It's because of a legal concept known as vicarious liability. And what does that mean? It means that the employer is responsible for the acts of its employees, legally responsible. Now, that's a big issue. Why is that? Because the doctor may not have sufficient insurance coverage to compensate you for all of the harms and losses and injuries you suffered because of his carelessness. So in that instance, not only do we bring a lawsuit against the careless doctor, but we are obligated to also include the doctor's medical group where he was working at the time, the professional corporation, to also include them in the lawsuit because technically they are legally responsible for the acts of the doctor who is working there. Likewise, if the doctor was working for the hospital, we have an obligation to go ahead and sue the hospital as well for being the employer, because they have an obligation to go ahead and supervise the acts of their employees. And if it turns out that the jury ultimately down the road during trial finds that the doctor was careless, then guess what? That carelessness is then imputed to the employer, which means that the employer is now responsible to pay any judgment, any amount of money that the jury determines is appropriate to you, the injured patient. So that's why we will always look to see where was the doctor working. Was he an employee? Was he a partner? Was he part of the hospital? And then we will include them in the lawsuit, even though the other staff or the other people in that medical group or the hospital may not have participated in your care. But from a legal standpoint, it will allow us the opportunity to show that they are vicariously liable, that they are responsible for the acts of their employees. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I do understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.